Breaking news, the top secret Pentagon documents have been leaked to the New York Times. The New York Times started publishing these papers on July 13th. Today, we will be discussing the New York Times versus U.S. Supreme Court case that was decided June 30th, 1971. The case also known as the Pentagon's Papers case. New York Times versus U.S. is a debate over the extent of the First Amendment of the Constitution of the United States. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. To accurately understand the New York Times versus U.S., we should know the context. Here are a few things you should know about the timing of the court case. From 1964 to 1973, the United States was involved in the Vietnam War, and during times of war, the rights in the First Amendment are often questioned because the right of speech can put a country at a serious disadvantage. Before the court case, prior restraint was still in effect. This means that the government had the right to prevent the publication of information. The United States Department of Defense wrote a top-secret document called the Pentagon Papers. The Pentagon Papers was a project of 47 volumes, almost 7,000 pages of secret work. There were only 15 copies made. In 1971, Daniel Ellsberg, United States military analyst, wanted to end the Vietnam War and hoped releasing the Pentagon Papers would encourage that cause. He gained unauthorized access to one of the 15 copies of 7,000 pages of top-secret Pentagon Papers and handed them to the New York Times. The New York Times began to publish the classified documents. Of course, the New York Times versus U.S. Supreme Court case happened. Here are the facts. Top-secret military documents are leaked to the New York Times. The New York Times began to publish the documents. The U.S. attempts to block the publication of the documents. The question that the court considered is whether or not the First Amendment of the Constitution protects the publication of classified documents related to national security. The court decided that the First Amendment of the U.S. Constitution does protect the publication of classified documents related to national security. The decision was a 6-3 ruling. Because the case was decided so quickly, the judges did not develop a consensus position. Rather, they each formed their own concurring opinions. These opinions varied in reason. Let us go over some of the opinions from the justices. Justice Black argued that free speech was necessary in order to let the public detect any detection in the government. Another justice argued that the freedom of the press should not be an unrestricted right, but recognized the danger of allowing the government to have complete censorship powers. The dissenting opinions generally argued that the case had been decided far too quickly, and criticized the danger this could have on the government when important things were at stake. This case has made it more difficult for the government to convince the courts to allow them the ability to censor. The court's fractured majority fails to say prior restraint may never be imposed, may be only imposed if the threat to national security can be proven to be real, serious, and immediate, or may be imposed if Congress provides sufficiently clear authorization and guidelines. Thus far, being an unambiguous declaration of support for a free press, the decision leaves open the possibility of government censorship without specifying the conditions under which the First Amendment may permit it, as noted by Stephen Robertson. Thanks for watching.